What part of the offence defined in section 377 has been declared unconstitutional by the apex court and by which judgment, and which part is still an offence? Now, after this judgment, which we are now going to discuss, part of section 377 has been struck off, having been declared as unconstitutional. Part of section 377 is still in force and applicable. So we need to very clearly know as to which part has been struck off and which part is still there. First, let us see the name of the judgment. Section 377 itself is this: whoever voluntarily has carnal intercourse against the order of nature with any man, woman or animal. Against the order of nature. Alright. So the name of the case is Navtej Singh Johar versus Union of India. This was rendered in 2018, overruling the earlier judgment of the Supreme Court itself, Suresh Kumar Kaushal versus Naz Foundation. Now, section 377 is partially struck off and the remaining part is still in force. Since 2018, this is the position. Let us see which parts and what are the grounds. Now, the Supreme Court says that a part of section 377 is manifestly arbitrary and therefore violates Article 14. Which part is arbitrary and which part therefore violates Article 14? We'll see. The court says section 377 IPC, so far as it criminalizes even consensual sexual acts between competent adults, fails to make a distinction between non-consensual and consensual sexual acts of competent adults in private space, which are neither harmful nor contagious to the society. So the emphasis is on consensual sexual acts between competent adults. Clearly, this part should not have been criminalized, and that to the extent that section 377 criminalizes these types of acts, it is unconstitutional because it violates Article 14. So this is one ground, and the second ground is 19(1)(a). On the basis of 19(1)(a), the court says an examination of 377 on the anvil of 19(1)(a) reveals that it amounts to an unreasonable restriction. Now 19(1) gives freedom of expression and 19(2) allows reasonable restrictions by law on this freedom. The court says that the restriction imposed by section 377 is unreasonable. What is the ground on which this restriction has been imposed by law by section 377? On the ground of public decency and morality. You will recall that under 19(2), 9 grounds are given on which restrictions can be imposed, reasonable restrictions can be imposed by law. Decency and morality, public decency and morality are 2 grounds on which reasonable restrictions can be imposed on the freedom of expression. The court says that the restriction imposed by 377, or rather a part of section 377, cannot be justified because the restriction is unreasonable, and the reason is that public decency and morality cannot be amplified beyond a rational or logical limit and cannot be accepted as reasonable grounds for curbing the fundamental rights of freedom of expression. Which right is being encroached upon? The fundamental right of freedom of expression and choice of the LGBT community. Consensual carnal intercourse among adults, be it homosexual or heterosexual, in private space does not in any way harm the public decency or morality, and therefore section 377 IPC in its present form violates Article 19(1)(a), freedom of expression. So 2 fundamental rights have been violated by a portion of 377, not the entire 377, a portion. Now we will see which part has been declared as unconstitutional. And the corollary is that the part which is declared unconstitutional has been struck off. It is now no longer a part of the statute. Section 377 IPC, so far as it penalizes any consensual sexual relationship between two adults, be it homosexuals, that is a man and a man, heterosexual, a man and a woman, or lesbian, a woman and a woman, cannot be regarded as constitutional. So now it is no longer an offense. Consensual, yes, there must be consent of both the parties. If there is consent of both the parties are adults, then sexual relationship between them, regardless of their gender, is not an offense. That is first part. And some part of 377 is constitutional, therefore still in force, therefore valid, which is that part which is still in force. If anyone, whether a man or a woman, engages in any kind of sexual activity with an animal, then the said aspect of 377 is constitutional. It shall remain a penal offense under 377 IPC. Therefore, as of now, sexual activity with an animal by a man or a woman is punishable under 377. That is one thing. And secondly, any act of the description covered under 377 IPC done between two individuals without the consent of any one of them would invite penal liability under 377 IPC. If the sexual activity is consensual with the consent of both the parties, then it is not punishable. If it is consent of one of the parties is lacking, then it is punishable whether the sexual activity is between a man and a man or whether it is between a woman and a woman. Of course, if it is between a man and a woman and there is no consent of the woman, then it is punishable under 375 itself, being an act of rape. If there is a sexual activity, sexual intercourse between a man and a woman, it is an heterosexual act. It is not against the order of nature, and therefore it is not at all covered by 377. Please remember, a sexual intercourse between a man and a woman is not covered at all by 377 because it is not against the order of nature. Such an activity, a sexual intercourse between a man and a woman without the consent of the woman, is punishable under 375. But on the reverse, a sexual intercourse or sexual activity between a man and a woman without the consent of the man is not at all punishable. So that is only one thing, the only kind of activity, sexual activity, which is not punishable even if there is no consent of any of one of the parties. Every other is punishable.